I have written that I will strike that, my lord.
Okay.
The only thing that I would like to point out from our side is the lordship will go through the prayer portion of the writ appeal, my lord. And the prayer, if what they have made, I believe if that in view of the prayer they are seeking from this honorable division bench, perhaps all these arguments are not necessary because their prayer is something different and they are arguing something different.
My lord, I understand my case better than my learned friend. So I have placed everything there. Your lordship can go into it. And if there is any confusion, my lord, your lordship can hear it once again.
Okay. No, but should we conclude to really ask the written argument? You want to see it now? Let us just see the impugned order.
My lord. That your lordship will find at page 171. Lord, should I have to go through it? Relevant part your lordship will find page 188. See, my lord. While examining the matter, it would be open to the said authority to examine whether the MPhil and PhD degree granted to the petitioner would entitle the petitioner any advantage in securing appointment to the post of assistant professor in computer science in the concerned college without commenting on validity or otherwise of the degree, as the validity of the degree is not under challenge. Even, my lord, if they were aggrieved at all, the University Grant Commission, UGC, my lord, they could have filed an appeal before this honorable court. They did not. So therefore, this has reached its finality. And my lord, the appeals court decision I have relied, my lord, when it reached its finality, if you want to still argue, then it is the abuse of the process of the court as held by the apex court. Because law of estoppel and issue estoppel comes in. Now, so far I am concerned, your lordship will find I obtained my MPhil degree way back in 2008. Then 2008 onwards, till the date of advertisement, that is on 2017, I gathered teaching experience of 9 years. And on teaching experience, your lordship will find I'm entitled to get maximum 5 marks. And 2 of the colleges have they have given 5 marks, and only one, the same subject teacher, they have given no marks at all. Now, these are the arbitrariness your lordship will find in this case. And ultimately, my lord, learned single judge held that the degree is valid since nobody is challenged. So I am entitled to get 5 marks for my MPhil degree and 5 marks for the teaching experience. And so far, my teaching qualification, your lordship will find that I have obtained my PhD degree way back in 2014. So there also I am qualified teacher, qualified assistant teacher, since I am the holder of PhD degree. So for qualification is concerned, there is no problem at all. Only thing, my lord, the experts, they have said I am entitled to get 5 marks for MPhil degree as well as teaching experience 5 marks in 2 of the colleges. And the third college, my lord, they have found I am entitled to get same subject matter. They have made a somersault. They are making I am entitled to get 0 for my MPhil degree and 2 marks for experience. There is no reasoning why they have done that. That way I explain in my written argument, my lord, very comprehensive.
Just one line, my lord, if lordship would like to listen. That page 188, point number C. If I may read once more. While examining the matter, it would be open to the said authority to examine whether the MPhil and PhD degree granted to the petitioner would entitle the petitioner any advantage in securing appointment to the post of assistant professor in computer science in the concerned college, without commenting on validity or otherwise of the degree, as the validity of the degree is not under challenge or in question. Where is that affirmation made by the learned single judge that this degree is valid? Learned single judge, in my respectful understanding, my lord, maybe I'm wrong, subject to correction. The plain reading of this paragraph says that we are not, the learned single judge is not commenting upon the validity or otherwise of the degree because it was not under the challenge. Does it mean that it has attained its finality? It is still open for any authority, competent authority to challenge. It is still open to the competent authority to examine. And moreover, they are not asking to quash this particular paragraph. Their prayer is something different. Kindly see, my lord, at page 22. Starts from 21. Their prayer is different, my lord. And they are harping upon this paragraph. And my lord, to my humble understanding, it does not mean that the MPhil or PhD MPhil degree for this purpose, PhD not in question, MPhil degree obtained by this petitioner has been declared to be valid by the honorable single judge, which has not been challenged by anyone. It does not mean that, my lord.
My lord, that is his interpretation. It is up to your lordships, my lord.
Yes, yes, of course, this is up to the court, my
The
lord.
interpretation your lordship kindly see.
It is of course up to the court, but
Learned single judges
my
say-
duty is to argue my case, my lord.
The learned single judge has said whether it gives an advantage. Now, so far the degree is concerned, learned single judge has emphatically said is a valid degree. Now, the 100 persons can interpret in 100 ways. But the interpretation should be in terms of what learned single judge has said. And whether
We asked them to file a review of it.
Huh?
Why didn't you file your written argument?
Well, it will file, well, we have got the today only, we will file our reply.
no, your lordship, the last so many occasions, your lordship has already said to
No.
file this.
We'll file it too.
When can you file it?
A week time, man.
I'm sorry. Let them file.
You will not be here. no?
Agent when a lordship is available.
Well, one thing can be done for filing their written argument. The constitution of bench possibly not required. They can file before the registry also.
That is, let it come before the bench.
It's all right.
It's easier.
Third is the senior law. Assisted by Mr. As the third. As the third. Mr. Gogol, you also first.
What one?
Or Mr. T. Gogol and Standing Council, higher division, and Mr. T. Jama, the Standing Council, are allowed 2 weeks time. to file the respective written argument.
Written out.
List of the one.
Much of it.
What one?
One and 22 lordships may be taken up in the second week of August, my lord, but still has some difficulty today.
Item 21.
1 and 22 lordships. I am for
That
the,
goes with 23.
yes, my lord.
Lordship, herein I appear for the petitioner, Lordship.
Oh,
Lordship, since he has expressed some difficulty in being posted.
okay, who's the, you're the?
I
I'm
am
for,
respond.
I'm for the Espondercy Cotton University on behalf of PD Nair lordship.
Okay.
Lordship, I have one more prayer, Lordship. In item 21, I have the instructions not to praise this matter. Item 22 and 23 may remain, but item 21, Lordship.
Okay, item 21, you're right. Mr. M.P. Sharma, learned counsel for petitioner. Submits that he has instructions not to praise. Stop. Higher education who appears? Mr. N. Guyan, learned standing counsel appears for the higher education.
22, 23.
And you are appearing for Cotton University.
Yes, Lordship.
Mr.
H. Rahman on behalf of PD
Mr.
Nair.
H. Raman, learned counsel. Appearing on behalf of Mr. P.T. Nair, learned standing counsel.
Yes, Lordship.
Cotton University. Appears for the Cotton University. Stop. With petition, it's accordingly dismissed on withdrawal.
Item 22 and 22 will remain, Lordship.
Yeah.
We adjourn.
Item 22 and 23, you're right. First, Mr. M.P. Sharma, learned counsel for the petitioners. On request made on behalf of Mr. P.T. Nair, learned standing counsel. Cotton University. When do you want?
Second week of my Lord, August.
Okay. 12th,
Lordship.
okay.
Yes.
Or should I will not give a date.
My Lord, no date.
Huh?
Second week, Lordship.
Or just say,
Lordship will fix a date because it's pending since long, Lordship.
okay.
Yes, Lordship, 12, Lordship, 12, Lordship.
On 12.
Lordship, I have one more request. In item 20, Lordship, I appear for the petitioner. Lordship, I have not received any instructions in this matter, Lordship. Can this matter be accommodated for today, Lordship?
Okay, on request made by Mr. M.P. Sharma, learned counsel for this petition. When do you want? 2 weeks?
Lordship.
Is the matter of item 3.
My lord, this is the contempt case, my lord, regarding non-compliance of the interim order, my lord. Matter relates to appointment of in-charge principal, my lord. So the matter is very urgent, my lord. It may come up on
Is it the
Monday.
pending contempt case or a new contempt case?
Pending, my lord.
When do you want?
If possible, tomorrow, my lord.
31st.
Please. Also with the consent of the other side, I'd like to mention item number 18, Lordship.
Item?
18. Mr. DYSJ is out of station, so matter may be posted on next Thursday.
Who is out of station?
Mr. RK Chaudhary, Lordship.
Item 18.
18, Lordship. The part heard matter, Lordship.
Who appears for petitioner?
Taken the consent.
You have taken the consent?
Yes, Lordship, I have taken the consent.
Okay, on request made on behalf of Mr. R.K. Chaudhary, learned ASGI. Please the matter when?
Lordship, on 1st of August, next Thursday.
Okay, on 1st August.
Highly obliged.
May I please, your lordship, my lord. My lord, I have prayer for listing of a case, my lord. It is, my lord, long pending, my lord. This matter pertains to, my lord, provincialization of service of petitioners, my lord. It was about to be listed, my lord, after 4 weeks. And on last occasion, my lord, this was listed on 11th of January, my lord. But till date, it has not been listed, my lord. Matter is very urgent, my lord. Lordship will kindly fix the case in the next week, my lord. Monday or Tuesday, my lord.
First August.
My lord.
May it please your lordship, this matter, your lordship is sitting with Justice Goswami today. I have filed the written argument, but will not have a time to recall this when the bench when the bench sits. So may I pray that that matter may be called for, that arguments may be called for. We have filed in the.
That I can pass in order sitting as a single bench.
Okay. Deep breath. Lordship, I am praying for listing of 2 cases, my lord. On Monday, my lord. It's urgent, my lord, a transfer matter, my lord. Petitioner has been transferred, my lord, in violation of existing rules, my lord. The similar cases, my lord, already, my lord, heard, my lord, and passed status quo.
Monday, and many cases are listed.
Very urgent, my lord.
Okay.
By 1st of August, my lord, case will become infectious, my lord.
Okay, 31st July.
31st. My lord, Tuesday, my lord.
31st.
Allah,
That is before 1st.
Allah.
Lordship, with the consent of others, sir, I'd like to mention item number 7.
Yes.
In this case, I am appearing for the petitioner, my lord. My lord, can a date be fixed preferably on the next Thursday, my lord, 1st of
Chowdhury, you have.
I'm there in the petition, my lord. The person is out of job for 3 years. So,
You are
separate
appealing
date, my
for?
lord.
For Guwahati University.
The standing council has some personal difficulty, he informed me. Let it be on first, my lord, if he do not inconvenience.
First,
Okay, heard Mr. M.K. Chowdhury, London Senior Counsel, assisted by Mr.
T. Chakraborty.
T. Chakraborty, London Counsel. On the first met on behalf of Mr. P.G. Fukon, the Standing Counsel, Guwahati University. Mr. Matter of first you want?
first.
My lord.
First,
Now let me record my presence for the users.
Mr.
There's some more for the
G.
users.
Jamo, Standing Counsel, appears for the use.
My lord, may I beg to mention item number 26 to 28.
Yes.
My lord, these matters, there is prayer for provincialization, regulation of the service of my lord college teachers. So what happened, my lord, on somewhat similar circumstances, Honorable Justice Nair had passed a judgment. And when this matter came up before his lordship, then my lord, I tried to convince him to take a different view because my lord, certain facts and certain law were not placed when the earlier judgment was passed. His lordship, Justice Nair also heard the matter, but then it has not been kept its word heard. Since my lord, I am trying to, my lord, impress upon his lordship to take a different view. Can I pray that, my lord, this matter may be placed before his lordship? My lord?
Okay. Mr. M.K. Chowdhury, London Senior Counsel for the petitioners, submits that this matter has been extensively heard before the court of Honorable Justice U.K. Nair,
My lord.
and therefore submits that the matter may be listed before the same court
My lord.
as and when the court is available. Stop. Praise the Lord. How do we say?
My lord, no date can be fixed because his lordship is out of station
Yeah.
now.
I'll say list after 2 weeks.
Now let me record my presence. please.
Mr. T. Jamal and Standing
Yes.
Counsel appears for the
Users.
Easy.
In all the 3 cases.
Highly obliged.
Well, the previous matter, my lord, it was not me, my lord. I meant, made a mention for these 3 cases also, not in the previous.
which case?
Just my, Leonard Junior has mentioned the,
Item number 7, my lord, he is not there.
I'm not there in items.
Item 7, you just cancel. So appears for the UGC, no? Yeah, cancel it.
Obliged.
May it please your lordship, I beg for listing of a writ petition. It's a matter relating to release of the arrears salary.
When was it last listed?
It was last listed on lordship 26/6/2024.
6. Okay, 7th August.
Obliged.
Lordship, I beg to mention item number 24.
Yes,
Kindly adjourn the matter for today.
you are appearing for?
On behalf of M. Kolita for petitioner.
Okay, on request made on behalf of M. Kalita, London Counsel for the petition. List after 2 weeks. Yes,
May I please, my lordship? I beg to mention item number 20, as the senior counsel is out of court.
item
20.
that's already adjourned.
Much obliged.
Lordship, I beg to mention WPC 5359 of 2023 to be listed on urgent basis.
Hmm?
WPC 5359 of 2023 on an urgent basis.
What is
to be
the
listed.
urgency?
Client has some issue, medical issue.
What issue? What medical issue?
So I don't know, but medical issue, this much only I know.
9th August.
Item 1 and 2 of daily motion.
Lordship, let the matter be taken after some time.
One is
Yeah,
the-
तब तो देगा वैसे। One is already over here. Put number one है तो हो गया ना?
No. Oh, okay. What is it?
Let the matter be taken after some time, Mr.
Always on all the court hearing that only my lord. I'm tired of that. Every day. Yesterday also, today also in other court also. Time being, because we have got other items also. Let us start, my lord. He will come and reply.
Please don't let's at court one.
Court one of item number one only. Now it is fine.
Items.
Other items. Let us start. The lordship can be taken up when 11:30 hour.
Let him come, let him come.
Yes, but I'm going to another court, my lord, then. Item number 3 is there.
You finish your matter and come back.
Yes.
3.
May I please, your lordship? Lordship, I have filed the affidavit reply, lordship. Perhaps this is not in record, lordship. Yeah, before yesterday, lordship, I have filed
When
that
did you file it?
on 22, lordship.
22 or 23? Day before yesterday?
23, lordship.
23.
23.
23 years.
Then let it come on record.
No, no.
Mr.
And
If the child and counsel for the petitioner submits that he has filed an affidavit in reply to the counter filed by the respondent on 23rd of July 2024. Stop. Registry to verify and place the same on report, comma, if found in order. Please, when?
Lordship, Monday.
Monday, many cases are there. 31st?
Lordships, 31st, some personal, I have an outstation case with Lordships, either 30th or 1st, as per Lordship's convenience. First,
Okay, first,
1st of August,
first.
GP obliged.
Same, lordship.
Same order.
Similar.
Same order, both the matters are same.
Here also, it does not cost.
Same, lordship.
Same order, I don't think the
Yes.
reply will be on record because it was filed on the same day.
Let's take up.
Reply filed on 25.
Reply is not- Same order.
GP obliged.
Admission.
Lordship, Mr. Esquire will apply.
After some time, then Bora come.
Yes.
See.
That is as Bora, my lord.
Yes.
Lordship, matter lordship. I could not contact him. He's coming. Plus 5 minutes. He'll come. Yes. After some time, lordship, then.
None appears for the petition. List after 1 week.
File your please. 8.
Lordship, petitioner were appointed as an elementary school teacher in 1999. Lordship, thereafter petitioner has been given regular scale of pay. And thereafter, Lordship, GPF account has been opened. Page 36. Regular scale is, Lordship will find at page.
1 minute, BTC,
BTC has not filed an affidavit till date, Lordship. Lordship has granted so many times.
where's the BTC council?
My lord, but please to class over this matter for time being, my lord. Mr. B. Chaudhary is appearing for this matter.
Have you filed your affidavit?
No.
Not yet, my lord. We will file, my lord.
Are you filing or you're not filing? Give a specific reply. If you're not filing, we'll proceed with the matter. If you're filing, we'll give you time.
We'll file, my lord.
Lordship, there is a limit, Lordship. Lordship has already allowed last chance, Lordship.
Where?
I think on the earlier occasion. 4 times they have taken adjournment on filing affidavit. From 11/9/2023, they are taking time, Lordship.
My lord, 10 days will be granted, my lord. 1 week, my lord.
Lordship may again give 1 week time if necessary, Lordship. If they do not file the affidavit, Lordship will hear the matter.
Yeah, I'll give you 2 weeks as last chance.
My lord.
After that, no other, no further time. Heard, Mr.
SK Goswami, Lordship.
SK Goswami, learning council. On request made on behalf of Mr. B. Chaudhary, learning standing council, BTC,
BTC, my lord.
2 weeks time. As
10 days time, Lordship.
2 weeks.
2 weeks
Same
time.
thing, 2 weeks time as last chance. Is given to file contract. List of documents.
Lordship may record, Lordship. Otherwise, last chance, Lordship. Otherwise,
I've given last chance.
oblige.
9, 10, and 11.
Me, please, your lordship. In item number 9, my lord, I am appearing on behalf of the petitioner, my lord. On the last occasion, lordship was pleased to hear the matter at length, my lord.
Item number 9.
Item number 9, my lord. My lord, I'm just narrating the facts in brief, my lord. That, my lord,
Lordship, let the matter be taken after some time.
What?
Mr. Esbar will appear for SCRT.
Where's Gogoi?
item number 9, B. Gogoi is appearing, my lord.
A direction was given to produce 2
Yes,
orders
my lord. I have received the copies, my lord,
from him.
from my client, my lord. The reference of this letter that they have made in their affidavit. My promotion to the post of research assistant from statistical assistant was stayed after passing of the interim order in WPC in another writ petition, which is item number 10, my lord. And after that order was modified, those orders were withdrawn, my lord. So at present, there is no bar in considering me for promotion to the next higher post, my lord. If lordship,
You're appearing for on behalf of Gogoi?
My
No.
lord.
Huh?
lordship can peruse this
On
order.
legs, my lord.
Hmm?
He's on legs, my lord.
Then Deccan, let him come, let Gogoi.
My lord,
After some time.
my lord.
My lord, can I interfere, my lord?
Yes,
Yeah,
please.
regarding item number 10, my lord. 10 is that is unnecessarily I should take this along with this item number 9 and 11, my lord. Is it this item number 10 is a completely different subject matter. My appointment promotion to the post of the research assistant that has been under challenge, my lord.
What
So
is it?
last occasion also I applied this for lordship, my lord.
Item?
To split this item, my lord, from this to item number 10 and 11, my lord.
Complete your order.
9 and 11.
Agree then gets for hearing.
My lord,
It can be done today itself, your lord.
these petitions are tagged, my lord, on prayer made by me, my lord. Because, my lord, due to pendency of this writ petition, as my learned senior, my lord, stated before lordship, it has no connection with my promotion, my lord. But due to pendency of this 2 writ petition, I have not been considered for promotion, my lord. Subject matters are totally different, my lord. Therefore, this honorable court was pleased to modify the interim order passed in those batch of writ petitions, stating that, by clarifying that the interim order passed in those writ petitions will not hamper in my promotion process, my lord. And that order was passed in presence of the Council of SCRT. And now, my lord, they have taken the stand that due to pendency of these two writ petition, I am not liable to be considered, my lord. My only prayer is to my lord to consider me for promotion on next higher post. And they are not, my lord, later after some time.
Well,
May I please? Lordship, kindly peruse the last order, Lordship. They were asked to obtain instruction, Lordship, and they have placed instruction only saying that the DCRG amount has not been paid on the ground that
yes,
there-
Mishari.
Lordship, just now I have received an instruction, your lord. Instruction is a communication, your lordship, from the IS office to the petitioner, your lordship. Here it is written that with reference to the subject cited above, I have the honor to request you to submit all relevant documents, proposal, and audit clearance report issued by the competent authority to the office of the undersigned for settlement of final pensionary benefits at the earliest
that-
possible
that
time.
is it.
To the petitioner.
How the petitioner can place it, because I am not in service now. I retire.
Lordship,
It is the duty of the current principal, Lordship.
Lordship, the audit has to be as far as
No, there was an audit objection.
Lordship.
Now this court wants to know how you have dealt with the audit objection.
Yes, that
That
is
is
the
the
sole
whole
question,
issue.
Lordship.
Lordship, we had from the director office, your lordship, we have communicated with the principal. Principal is supposed to communicate with the petitioner for giving the audit report for clearance of his audit. Audit has to be done by the petitioner. He has to sit with the auditor and.
So who
clear
is the
all-
principal? Is the
Why not
principal a party?
Yes, Lordship, principal is respondent number 7, Lordship. He is not appearing, Lordship. I submitted the Dusty notice that has been, Lordship, received. And but still, Lordship, he is not appearing. He is opposing, Lordship. He is the main person, Lordship, because there was a litigation between the present petitioner and the respondent number 7 regarding the appointment of regular principal. In that case, Lordship, I succeed and he is out from the regular principal, because his B.Ed was in question. This honorable court set aside his appointment as a regular principal. Subsequently, Lordship, presently, Lordship, he is working as the in-charge headmaster, principal. Now he is not as a regular headmaster, a principal. Because I filed a petition against him, against the order of his appointment as a regular principal, questioning his B.Ed degree. Now, this is the rivalry, Lordship, going on between the petitioner and the respondent number 7. That is why, Lordship, he is not placing the documents for audit, Lordship, in respect of a certain period, Lordship, where
That
3
certain
months time
period-
I was the in-charge principal.
Lordship, in that certain period, he was the in-charge principal at
3
that
months.
point of time, your lordship. And that period remains unaudited because there are some financial irregularities. So he was the in-charge principal. He had not furnished all the details of whatever.
After that, Lordship, after 3
Where is
months,
that communication? Let us see.
that communication is to the petitioner, present petitioner. How he can, Lordship, I can assist, I can cooperate with the audit team, Lordship, if I have been asked. But he is saying that the
Lordship, as far as I can understand, your lordship, as my knowledge, audit has to be done by the petitioner himself to the competent authority, to the auditor. And auditor will give clearance and give a report, and that report has to be submitted to the school, to the principal.
absolutely not. That cannot be, Lordship.
No, 1 minute. In the last order,
Lordship,
this court directed you
lordship.
to take instructions
Lordship, this is the
as to how you have dealt with the audit objection.
Lordship, lordship, that is what we have communicated with the principal. And the inspector of schools has also communicated.
No, what is the reply of the principal?
The reply, earlier the reply that was given, your lordship. Lordship, yes.
The several times, Lordship, that reply was placed. They saying that principal is saying
Lordship,
that audit, there is a audit objection. That's why he has
Because
not
of the
given the NSC.
because of the audit objection, he has not been able to give NOC, your lordship.
That is the sole question, Lordship. He has to place all these things before the auditor, and whatever, Lordship, my presence.
No,
will
what
be
is
there,
the, you have written to the principal, isn't it?
Lordship, we have
What is the
written-
reply? What is the
and
reply?
Is that, your lordship? The Puranendu Sekhar Debnath has not maintained a cash book along with supporting relevant voucher invoice of all the expenditures incurred for the remaining subsequent period of his period of principal in charge. In absence of the record for the above period, the documents remain unaudited. As he had been serving as a subject teacher in the school up to retirement, after relinquishing charge as principal in charge on 2/5/2017, he was requested several times to complete the cash book and record for the period for audit purpose. The request was.
Give me the document.
Lordship. So I'll just receive. Lordship, I'll give after some time. I'll just give a printout and give after some time.
My lord, I think, Lordship, this letter will not solve this problem.
We'll see.
Yes, Lordship.
Let it come.
Lordship, item number 13 may be passed over for the time being, Lordship.
Why?
Lordship, the conducting counsel, Mr. P.R. Sharma, he is appearing in a different court, Lordship.
Have you filed your amended cost title?
Lordship, also item number 17, same conducting counsel, P.R. Sharma.
Let it come.
Obliged.
14.
May I please, your lordship? My lord, in this case, my lord, the matter pertains to provincialization of services, my lord. My lord, the affidavit from the other side, the state respondent is required, my lord, from the DLC and the director. They have not filed their affidavit, my lord.
What is this IA about?
My lord, IA has been that for they have filed, the other side has filed an IA, my lord, for vacation of an interim order, my lord. And they have, my lord, make their submissions and they have failed to satisfy the cause. That's why, my lord, the matter has been fixed for admission hearing, my lord, for final disposal. Well, the dispute here is just in the read petition that my lordship may stand the page 15, my lord.
Of the read petition?
Of the read petition.
Page?
Page 15, my lord.
Yes.
My lord, that is the performer, my lord, submitted by the headmaster on basis of which the service of the thesis has been provincialized. My lord, you'll find this on serial number 1, my lord, Renu Burman. She is the, my lord, respondent number 7 here, Asian. And the subject of is by her is English, my lord, on the right side, right column, my lord. And thereafter, my lord, will find that Nirupama Deka Hujuri, that the and serial number 2. And my lord, her subject is Hindi, my lord. Both are language teacher, and the petitioner is on serial number 3, my lord, Kalyani Devi, and she teaches, my lord, social study. Socialist teacher. So, my lord, as part of section 3.1.11, my lord, that the provincializations of that, my lord, social teacher is mandatory, my lord. One social, one maths and science, and one languages. They have, my lord, the provincial is the service of two teachers. This, my lord, respondent number 7 and 8. Instead of provincializing, my lord, the petitioner, both are language teacher. Now, one language teacher, they can, my lord.
Respondents 7 and?
Respondent 7 and 8.
6 and 7.
6 and 7, man. 6 and 7. That provincializations, the list of lordship will find on page 18, my lord. That is the list of provincialized teachers. The school names were reflected. Page 18. Serial number 78, lordship. On the left side, Kamrup, DLE. So and so school. There's a Renu Burma, respondent number 6.
Yes.
And thereafter, my lord, Nirupama Deka.
Yes.
English and Hindi, both are language teacher, my lord. So court, considering the aspect that the, my lord, there's the respondent number 7 is senior, my lord. And the respondent number 6 is junior. That's why, my lord, the service of the respondent number 6 has been, my lord, stayed. The provincialization of service of the respondent number 6 has been stayed until further order. They have filed, my lord, petitions, and, my lord, they have failed to satisfy the court, and court has, my lord, fixed the matter for admission hearing, my lord, for final disposal. Now, my lord, ascertain as to who taught what subject. Being a social, my lord, being social, I am very much entitled, my lord, as part of, my lord, the section 3111. So that is why, my lord, my humble prayer that let them file their PDP.
No. May I just put things in perspective, my lord? First of all, my lord, if your lordship kindly turns to the prayer, prayer is at page number 11, my lord. Prayer is at page number 11. Your lordship will see he is basically praying for provincialization of his services. That is his prayer. And, my lord, if your lordship kindly sees, my lord, how did he obtain the interim order? That your lordship will find, my lord, at page number 8, paragraph 9. This is how he obtained the interim order. In paragraph 9, he states that the petitioner begs to state that the writ petition of other similarly situated candidates is disposed of by this honorable court, wherein the entire facts and circumstances are same in the instant case. The order passed in WPC 3136 of 21/3657 of 21, 3401 of 21, and 3220 of 21, order dated so and so, being similar, has been annexed herewith and relevant portion has been quoted. So there is no dispute that the facts and circumstances of the instant case are very much similar to the writ petitions which have been mentioned in the writ petition. Now, what had happened, my lord? Initially, there was an interim order in these cases. Now, what had happened? What had happened, your lordship will find at page number 87, my lord, running page 87. Page number 87, my lord. If your lordship kindly turns to page 89, 89 is the relevant portion. Running page, my lord. Second paragraph. Considering the submission and taking into consideration the similar orders passed by this code, one which being order dated 31/8/2022 in WPC so and so, writ petition is disposed by granting liberty to the petitioner to file his appeal before the appellate authority in terms of section 14 of the Act of 2017 within a period of 1 month from today. So this is how all the similar writ petitions are disposed. And he himself states that if your lordship kindly turns.
1 minute, this is WBC?
WBC, same, my lord, WBC 3136. If your lordship tallies, page
1 minute.
If your lordship tallies page number 8 with page number 87, your lord.
Yes.
Page number 8 and page number 87, my lord, your lordship will see WBC is the same, 3136 of 21. And page number 88, if your lordship kindly turns, and your lordship will see advocate for the petitioner, same advocate, Mr. B.K. Das. Apart from these 4 admitted writ petitions, my lord, there are several orders of the decisions of the various coordinate benches, wherein all these matters have been sent to the appellate authority. For example, my lord, page number 112. If your lordship kindly turns to page 112 for a moment, my lord Justice M.R. Pathak, my lord, 112, 112, my lord. Your lordship will see, it starts at page, my lord, 106, and relevant portion, my lord, your lordship will see, my lord, 112, paragraph 24. Paragraph 24, my lord. It is seen that adequate alternate remedies are available to the petitioner, both statutory remedy under section 217 of the Act, as well as the concerned education tribunal having exclusive jurisdiction to adjudicate disputes claiming for provincialization in respect of teaching and non-teaching staff in terms of the law laid down by the full bench of this honorable court in Abdul Gofur Sukta. Similarly, my lord, if your lordship kindly turns to the next page, 114, my lord Justice Unnikrishnan Nair, relevant portion is 116, my lord. 116 relevant portion, second paragraph. In view of the aforesaid submission, this writ petition stands disposed of by directing the secretary to take on record the appeal dated so and so preferred under section 14. And next paragraph, interim order is vacated. Similarly, my lord, page number 121, your lordship's own judgment, my lord, page 121, paragraph 3, 121, my lord, your lordship's own judgment, my lord, paragraph 3, on consideration of the representation dated so and so, this court is of the considered opinion that the representation was made before the wrong authority. Accordingly, the petitioners are directed to file several appeals before the secretary, and the secretary shall consider those appeals. Similarly, my lord, Justice, my lord, N. Nanitagia, page 125. Page 125, my lord. And relevant portion is 120 at page 126. The last paragraph. The appellate authority shall dispose of the appeal filed by the petitioner as expeditious as possible after hearing both the parties. Similarly, my lord, Justice, my lord, M. Jothangkhuma, page number 129. 129. Relevant portion is at 130. Accordingly, this writ petition is dismissed with liberty, my lord, for the petitioner to approach the state government in terms of section 14. Well, in fact, Justice S.K. made his order is there at page number 137. Relevant portion is 138. My lord, 138, second last paragraph. In view of the above, the writ petition is closed by giving liberty to the petitioner to approach the appellate authority as envisaged under section 14. So, my lord, apart from these various coordinate benches, even the 2 division benches of this honorable court has held, which your lordship will find at page 146. 145 it starts, and page 146, my lord, you will see, my lord, 146 last paragraph. In that case, the provincialization of the private respondent was interfered with, and this is what the division bench had to say, page 146, last paragraph. We are inclined to allow the writ appeal on 2 grounds. Firstly, certain rights had already accrued in favor of the respondent number 8, 9, 10, and 11 in the writ petition as they have been shortlisted for provincialization. Learned single judge has stalled their provincialization without giving notice and giving them an opportunity of hearing. And secondly, it is an admitted case, as we are told, that when the petitioner's name did not figure in the list of teachers who were provincialized, she had filed an appeal on so and so before the commissioner and secretary under section 14, which is still pending disposal. And the next paragraph, in view of the above, we set aside the order of the learned single judge and direct the appellant and the respondents to approach the, my lord, appellate authority. Similarly, my lord, another division bench, your lordship will see page number 150. 150, my lord, same issue. And this is what my lord had to say. The second paragraph, we are totally in agreement with the observations made by the learned single judge, considering the fact that the dispute is between 2 private individuals with regard to the provincialization of service. The learned single judge has committed no error in coming to the conclusion that the appellant has the alternative remedy to approach the Educational Tribunal for redressal of his grievance as per provisions of section 19(2) of the Act. So, my lord, various coordinate benches of this honorable court and 2 different division benches of this honorable court had held that whenever matters of 2 private individuals are there, my lord, it has to go before the appellate authority. The alternative remedy is already there, my lord. And secondly, my lord, the writ petitioner has stopped coming to the school from January 2022. Presently, she is not in the school. If your lordship kindly sees, my lord, I have given the attendance register, page 152. From 152 to page number, my lord, 176. Since January 2022, she is not even in the school. And he has filed an affidavit. I have filed this affidavit in placing on record the attendance register, and he has admitted it. He has filed an affidavit on 14/5/2024. He agrees that the petitioner was not even in the school. This is the conduct.
Yes.
My lord, so far as this, my lord, he's saying that I'm absent in my school. That my lord, the services of the school has been provincialized in my lord, second 4th of
So
February.
I'm not going whether you are in the school or not.
Yes, yes, madam.
Now, what about the alternative remedy available to you?
Yes, my lord, may I just place some of the, my lord, that my learner page has my lord placed some my lord order passed by this honorable court, some coordinate was only my lord where my lord the section 14 has been taken. But there are numerous judgments wherein this honorable court has interfered and my lord the impugn appointment orders are set aside. So I would like to place this judgment, my lord, that there is some marks is there the impugn appointment. my
But
lord,
then in your paragraph 8 of your root petition, you have referred to those judgments
my
which
lord.
have been sent back for.
No, my lord, that is subsequent one. That is my lord in reference to interim order. My lord, that in similarly situated, this is my lord final order passed that the impugn appointment order has been
The
set
final
aside.
order was passed in those writ petitions we have relied upon at paragraph 8.
No, my lord, that is when I have initially filed that, my lord, that writ petitions when to my lord, obtain the my lord, in some similarly situated my lord, writ petitions, interim order has been passed. But this is the final order. That has been this honorable court has interfered and on the last my lord, underline and set aside the impugn appointment order of the private respondent who has my lord, illegally obtained their my lord, appointment. There's an emergency. I would like to, my lord, rely upon this the full bench judgment of this honorable court, my lord, where, my lord, it has been very clearly, my lord, stated. Just for a moment, your lordships can parallel. Page number 34, para number 34. That is the full bench judgment on basis of my lord, on basis of these judgments of the tribunals and my lord that has been my lord set aside in 34, my lord. Para number 34. May I read this? Now, this very clearly says that
This is on the basis of the Act of 2011.
2011, my lord.
This Act of 2011 was discussed, not 2017.
No, Act was discussed. It is very much in the circumstances has been very clearly narrated that there is there is no bar.
In 2011 Act, I'm not very well aware with the 2011 Act. Was there alternative remedy available?
No.
It was not there.
After this judgment, then this new clause came and the new act came 2017.
No, my lord.
And the
So
date of
far
this.
as so far as this my lord, alternative remedy, as my Lana train is referring the section 7. If your lordship will go to the section, if lordship will go to the section 14.
Thus, I think I've heard you enough.
No, my lord, just your lordship may pass any order, that is your lordship, but lordship may kindly allow me to make my submissions.
Yes.
Just I would like to place some judgments of Honorable Supreme Court. May I just my lord, very briefly clarify my contentions as regards to this my lord, alternative remedies concerned so far. My lord, section 7 very clearly says if a person's name has not been recommended by the DLC, then an appeal can be preferred by the before the SLSC. And if SLSC my lord, has not recommended name of any individuals, then appeal may be preferred before the concerned government. Now herein, my lord, there is no any fact, no any circumstance, no any evidences that my name has not been recommended by the DLC or SSLC. Now, herein what happened, my lord? That is as per the Act, my lord, the SLSC is not bound by any decisions or recommendations made by the DLC. It is not like not like my lord, compassionate appointment. The section 13(6) very clearly says DLC have to recommend the name of the eligible teachers who are entitled as part of
In your case, what happened?
my lord. I am social study teachers, my lord.
Your case was recommended by the DLC?
My lord, there is no any provision to communicate me. I am not aware, my lord. I have only come to the knowledge when the list of my lord that my lord.
Yes.
Let him file an RTI, and other thing is that there
No,
are disputed
RTI,
facts.
why?
No, whether the DLC recommended the case of the
No,
petition?
my lord, not recommended his name, my lord.
My lord, my lord, that is his verbal submission. Let him place the cause or file. How can
He is a stunting counsel.
Depending on maybe, but there must be some. He is representing the authority. He is not the authority. How can he say where is the document? There must be something, my lord. His verbal on basis of his verbal submissions. How it can be possible? That's why I'm saying let him that my lord that my lord filed an affidavit that my name is recommended. My name has been recommended thereafter, my lord. It will be
Here
done.
disputes of fact. Let him approach the tribunal, my lord.
No.
My lord, here, as per the statement made by the respondent, my lord, he is absent for last 2 years, my lord.
No, my lord, last year,
Well,
what
other
disputed?
thing is that
This is
what he has
irrelevant fact.
stated here,
Lordship,
my lord.
just let me, my lord, one thing, my lord. He's saying that I am absent from the my lord, 2022. No, my service has not been provincialized, and provincialization has been made in the year 2021. My service has not been provincialized. Why? How can I, my lord, continue in the school? Every person whose service has not been provincialized, they have left the schools. I do not have any right to approach the school.
Let him
After my prior provincialization, there is no any.
nothing.
Mala, that's what I'm saying. I'm challenging the appointment order of the private respondent.
No, my lord, that is not his prayer, my lord.
I'm saying, your lordship may kindly see, I have annexed.
No, his prayer is there for question.
Yes. Mala, they are not aware whether my name has been recommended or not. Let them, Mala, file their affidavit.
Recorded, my lord, his name is not recommended.
No. How can? Mala, there must be some record. They are representing.
Recording is submission. What
Mala,
more
your
do you want?
recording is not enough. Mala, the fact hearing is that. Mala,
So what is enough? According to you, what is enough?
Mala, let him file an affidavit. Mala,
No,
place
Mala,
the,
it is not.
only the
It is within
minutes.
the discretion of this court whether to permit them to file affidavit or not.
My lord,
If this court is satisfied with the submission made by the learned standing council,
then lordship, my lord, if my lord, then lordship may kindly fix the date for hearing as per your lordship's convenience.
I fixed it for
On
hearing on the last occasion.
On
This
his
case is
request.
fixed for hearing today.
On
Yes.
his request.
No, he's not my request, my lord, the admission that my lord, it has been the writ petition was listed in the wrong column, in the IA column, even though the writ petition was, my lord, fixed for admission hearing. That's why, my lord, the writ petition has been fixed for admission hearing. So far as the maintainability of writ petition is concerned, lordship may fix the date, any date for your lordship's convenience. I will on that particular
We'll
aspect, my
fix
lord.
it tomorrow then.
My lord.
Or your lordship can fix it for hearing as per his wish, but the interim may be vacated.
No. Interim order already he has filed, my lord.
Tomorrow.
Thereafter, my lord, that order has been.
Okay, on request made by Mr. B.K. Das, the counsel for the petitioner. List the matter for admission hearing
Tomorrow.
That is 26.
Obligation. DP obligation.
Oh, my lord, I am sorry, my lord. Item number 6, my lord, I was on leave, so lordship, whenever the matter was called up, I could not appear. So my appearance may be my lord, sorry. Item number 6 is already lordship has fixed next week, but I was on leave, my lord, which I could not.
So what do you want?
My lord, if it is non-appear, my lord, I will be so, my lord.
Okay, on item 6. What order was passed?
It is fixed in next week, my lord.
Yes, sir. Okay, on request made by Mr. P. Mandal, then a counsel. List after one.
Must.
That's,
15.
Let me lordship. In this case, lordship, I have challenged the action of the deputy district commissioner. Lordship. I have challenged the action of the district
Before
commissioner.
your lordship hear him, with preliminary objection, this is a private institution and the writ will not lie. You know, I will take your lordship.
That is our case, lordship. That is our case. Because here in this case, lordship, district commissioner has passed the order. If your lordship kindly come to page 34.
Have you filed your affidavit?
No, my lord, yet to file.
Page 34, lordship.
Yes, you can file it, but your lordship kindly see paragraph 18, my lord. Whether they can say anything in this writ petition.
My lord, in fact, lordship, my learned senior counsel, lordship, whatever is submitting, lordship, that is my case because I am challenging the action
Paragraph
of the
18,
district commissioner.
75.2, my lord. Your lordship kindly see that.
Para?
Paragraph 18. Then the Supreme Court decision have been cited. I will take your lordship to 75.2 in this para itself. Even if it is assumed that an educational institution is imparting public duty, the act complained of must have a direct nexus with the discharge of public duty. It is indisputably a public law action which confers a right upon the aggrieved to invoke the extraordinary writ jurisdiction under Article 226 for a prerogative writ. Now, this line is important, my lord. Individual wrongs or breach of mutual contracts without having any public element, as its integral part, cannot be rectified through a writ petition under Article 226. This is recently, my lord, concluded by Appeals Court in 2023. That is in St. Mary's case. my lord. So therefore,
My
it's a
lord-
public college. I don't know how the writ can be maintainable at all.
My lord, that is my sole contention in the repetition also.
You are appealing for respondent,
I am for, my lord, the college authority,
the principal,
principal, my lord.
respondent 5.
Respondent 5, yes.
5 to 11,
5 to 11, my lord.
14, 15.
5 to
5 to 11, then 14, 15, 16, almost all except few, my lord.
okay.
My lord, in this case, lordship,
If lordship wants,
If-
I can file an affidavit.
affidavit of the lordship, district commissioner is, will be essential because I have challenged the action of the district commissioner. I am not challenging my appointment, termination, etc. I am challenging the action of the district commissioner. That is page 34. This is the impel order in this notification in this expedition lordship. I am very much that is this writ petition under Article 226 is not maintainable in respect of selection, appointment, constitution, etc. of the managing committee, etc. That's
Okay,
why
let
lordship.
him file his
Yes,
affidavit.
lordship, he can, but
But Mr.
affidavit of the district commissioner will be needed in lordship in this case. lordship.
Are you filing your affidavit? Heard Mr. M. Khan and the counsel for the petition. Mr. S. Dr. the senior counsel. Appearing on behalf of the, I'll just say respondent 5.
My lord, I'll give the number to.
Okay, on appearing on behalf of the respond number 5, then he'll give you
Yes.
the number. Praise for how much time?
4 weeks.
Praise for 4 weeks time to file an affidavit raising preliminary object. Yes. Praise allowed. This after 4 weeks. In the meantime, the other respondents shall also file the respective.
No particular lordship, the district commissioner. His
That
power
we
he has
can't
to show.
see the-
My lord, in fact, this writ petition has been infructuous because, my lord, in the meantime, this person has been dismissed.
My lord, against that, we
My
are
lord,
going
he
to
has
file-
swallowed 40 lakhs from the college in his pocket. This is the conduct of this person, and he has moved an anticipatory bail. Now, this is the position.
and that is granted, that is not same, my friend.
Granted,
Bail
bail
is
is
been
not
paid.
acquitted. It's a bail. He thought interim bail is acquittal. That is the understanding.
They can file FIR and so that can be was
He'll go to jail, don't worry. Oblige me.
obliged.
Item 1 and 2, motion.
Alright,
May it please the lordship. I mean, item number 1, my lord. In this matter, my lord, what happened? My lord, the petitioner was appointed.
1 minute, 1 minute. Bora, you file your affidavit, isn't it?
Item 1, I have not filed with affidavit.
Huh?
The motion stage, item 1. no.
Item 1, you have,
Item 2, every pending is complete.
item 2 is case.
Item 2,
Item 2 is quite clear.
notice is one of them. In the item 1, notice has not been issued.
No, both are coming up for motion.
Both are coming up.
Isn't it?
Actually, totally different. my lord.
Huh?
Actually, totally different. So your option is to take up independently. Although,
Both-
request,
both-
the petitions are tagged together, but my lord, actually totally different. So my lord, we have. to
Payers
take
are same,
them
both ones, old pension scheme,
Regarding that is the pension.
old pension scheme, they want.
If file call as to homo. If we did it.
Maybe the prayer is same, but then the circumfacts and circumstances may be different.
It always be different, my lord, but the pair is same.
All pensions.
Then let it be segregated.
Lordship, that can be done. And Lordship will, item one, Lordship will issue notice and segregate it. And in the meantime, I'll file my affidavit.
And two can be disposed of because he has already filed 3 affidavits.
Okay.
All pleading is over.
In fact, my lord, item number 1 is very simple, my lord. Because, my lord, I was appointed in the year 99 under Operation Blackboard, my lord. Thereafter, my post was converted into non-plain post, my lord, in the year 2003, my lord. Thereafter, my lord, in the year 2009, my service was once terminated, but that termination was withdrawn in the year 2015, my lord. Thereafter, in the year 2015 again, my lord, regularized my service, my lord. Therefore, my service has been continued since 1999, my lord. Again, in the year 2022, the authority has issued another order posting me in some other school, mentioning that my service has been regularized. Already, my service has been regularized. Thereafter, I have joined in that school, my lord. But on retirement, they intimated me that you are going to retire, so you have to submit documents for NPS. But my service was continued from 1999. Then how I am entitled to the pensionary benefits under the NPS, my lord? I must be obtained the benefit of pensionary benefit under the rules, my lord.
Okay. Third, Mr.
M. Soikia, my lord.
M.
Soikia.
M. Cycle and counsel to the pitch. Stop. We'll keep it in the motion stage in this one also.
Because I have to file a affidavit in this.
I'll allow you to file.
Not so.
As well as Mr. S. Bora, the standing counsel.
BTC.
On the prayer made by the parties, segregate this matter from WBC 6976 of 2020 and release the matter on its own. How much time required?
At least 3 weeks time, man.
On its own after 3 weeks. So, in the meantime, as Bora, the standing counsel shall file after.
Obligations.
Yes, I can.
Yes, my lord. Made prisoner lordship. Yeah, my lord, the petitioner was initially appointed as stipend teacher, my lord, in 1999. The appointment order is annexed on page 15. Initially, he was appointed as stipend teacher. Thereafter, my lord.
1998?
1999. On date, my lord, is my lord 4/12/99.
Yes.
Yes. Thereafter, my lord, page 28, he has passed the basic training course.
Page
28. He has passed the basic training course. Thereafter, my lord.
When did you pass?
I passed basic training on my lord certificate is 2004.
Huh?
No, copy. That is my lord, 3rd of April 2004, certificate was given. Third of April 3/4/2004, he has received the certificate for passing the basic training course. Thereafter, my lord, his service was regularized, Annexure 7, page 31.
Lordship will kindly see the page 31B because it is more distinct. His name is at serial number 3. The following incumbents are hereby allowed to draw the time scale of pay. Earlier, initially, he was getting the fixed pay. So, my lord, page 31B, the following incumbents are hereby allowed to draw time scale of pay so and so plus other allowance as admissible under also effect from the date of original name as they pass junior basic training examination. Regular salary against the valid sanction post. The post was originally created by number so and so, brought under so and so, creation number so and so, dated 2/2/2000. So retrospectively, their service was regularized.
No, you're given time scale.
Time scale, and my lord, it is non. They have been shifted to non-plain. Admissible if he has a draw regular salary against the valid sanction post.
What is the date of this order?
Date of this order is 21st March 2005.
Okay.
I've given the type copy also, 21st March 2005. So his service was regularized against sanction post. Thereafter, my lord, the letter is there, my lord, that per month, some year salary, some page 32, in persons of the order dated so and so, director so and so, following incumbents are hereby allowed to draw the time scale. It was increased, my lord, effect from the dates shown against their name as they passed the training course so and so. Thereafter, my lord, I'll first place the termination order. Their termination was page 36. Page 36. The entire list. And my lord, I have given a typed copy in my lord, page 36. And page 36A, the typed copy. His service was terminated that in pursuance of the government order noted so and so, WBC so and so, the services of 286 would on 302 teachers appointed by Darong district as per list appeared in the inquiry report of the Deputy Commissioner Darong and the inquiry report of the Director of Elementary Education Assam are hereby terminated with immediate effect. His name serial actually is 198. And the main list, his serial was 198, their service enter my lord, 302 teachers service were immediately terminated. That is the termination order, my lord. Page 36. Thereafter, my lord, there is a division bench order. The teachers, other teachers, my lord, they approach this honorable court. First, let us read the division bench order, then I'll come to his order. Division bench order is at my lord. Page 63. Starts from page 62, my lord. Is the division bench order. That is the leading case, my lord. Your lordship was also one of the signatory. Page 64, I'm reading. That the council appearing for the BTC, from the below third paragraph, my lord, from the below third paragraph, the council appearing for the BTC submits that the policy decision is taken that the persons receiving regularly salaries from the month of March 2006 would be regularized and the implementation of the policy is in progress. The government of Assam has also agreed to the said policy. In view of the above submission, the read appeals are disposed of with direction to respondents to effect regulation as per the policy decision of all those eligible teachers who were regularly receiving salaries up to 17/10/2006. Needless to say, if any of the appellants is aggrieved in the decision making with regard to the tenure of their service rendered and receipt of salaries, they can approach this court by separate petitions. So, my lord, this was, my lord, your lordship order in the division bench. Then, my lord, after that order, I also approached this court, my lord, that is at page 42. My name appear at serial number 3 internally. And there also same file on it. So saying he has passed the order. Page 45, last paragraph. The relevant paragraph I am reading, my lord. It is seen that the petitioners herein are persons similarly situated as in the case of the appellants in the bunch of writ appeals and as the case of the petitioners in WPC number so and so. Having regard to the above, this writ petition stands disposed of by holding that the petitioners herein are entitled to the same benefit flowing out of the order dated 6/2/2015 passed in writ appeal number 182 of 2013. It is, however, clarified that while making necessary exercise for effecting regulation of their services, the Education Department, Boroland Territorial Council would verify the case of the petitioners and reach a conclusion as to whether they were regularly receiving salary up to 17/10/2006. In the event they had received a salary up to the said period and had been serving in respective schools under the jurisdiction of Boroland Territorial Council, their salaries be accordingly regularized, services be accordingly regularized with the above findings and direction. This writ petition stand disposed of. So, my lord, following the order of the division bench, this order was passed. Now I'm coming to the payment of salary, my lord. Whether I was getting salary at that time or not, my lord, as fixed. That is, my lord, a certificate was given by the block elementary education officer, page 33. Page 33. Certified that Mohammed so-and-so, assistant teacher in Antoli Samba LP School under this Kolanga block, now at Korabari block so-and-so, has drawn his monthly salary from 6/12/99 to 28/2/2007 from this block. So up to 2006, as fixed by the division bench, he was receiving salary up to 2007, my lord, not only 6. 28 February 2007. Another also certificate issued by the headmaster, my lord, that it is hereby certified that so-and-so was getting his salary regularly to the month of June 2008. But since the month of July 2008, as there was no retention, he was not getting the salary since then to till date. So-and-so is working till now in so-and-so Rantoli Samba School as assistant teacher. Now, my lord, after the High Court order, my lord, regarding reinstatement of service, his other colleagues where, my lord, their reinstatement order is at page 47, your lordship will come. Other colleagues who were appointed together, getting scaled together, terminated together, were reinstated, page 47, that in pursuance of the Honorable Guwahati High Court order dated so-and-so, passed in WS and so, Petitioner was so-and-so, C so-and-so, assistant teacher, who was terminated by the DE, Assam so-and-so, dated so-and-so, is hereby reinstated in the same service and adjusted against the sanctioned vacant post in the same school as so-and-so, so-and-so. The teacher concerned shall not be entitled back wages for the gap period of so-and-so till that issue of reinstatement order so-and-so. So, my lord, they were reinstated. Another person reinstated. Then, my lord, page 48 also, that is also reinstated. His name is Pradeep Sonal. And this one name is Binoy Shahoria.
Where's your reinstatement order?
But my reinstatement on my page 49, my lord, I have been given fresh appointment instead of reinstatement. That is my grievances why I have come. Page 49, I'm reading, my lord. The resume, Secretary Borderland so and so, that is so and so, subject to police verification, satisfactory police verification report of the opposition physical fitness certificate, as if I am on a fresh appointment. Fitness certificate from concerned Joint Director of Health Service. The following candidate is hereby accommodated as assistant teacher in LP school on purely temporary basis in the pay band of rupees so and so plus grade pay and allowances as admissible under the Assam Service Revision of Pay Amendment Rules 2019 under the DO Odalguri with prospective effect from 1/11/2020.
Yes, impugn. You're impugning this order.
Yes, my lord. I'm challenging this order. My lord. Because, my lord, order was issued in 22 and I have been given off although even from 1/11, 1st of November 2020, other, my lord, my other colleagues who were appointed on the same date, and my lord, there's
This order is not
also-
impugnement. This appointment order is not impugn order. He wants modification this order.
modification disorder, that definitely
impugn.
because that can be technically, I cannot challenge it for setting aside. Technically for modification, that is my prayer, my lord. Because, my lord, instead of reinstatement, as per order of the Honorable Court, I should have been reinstated, but they have appointed the given appointment of fresh benefit. The fresh appointment will deprive me from pension also and other allowances also. And moreover, for the period I have worked before termination, that period I have to receive the salary. Till termination, when I have worked, till termination, for few years I did not get salary. That period has to be paid because it is after 2006. From 2008 onwards, my lord, they have stopped. So, my lord, the salary, my limited pay is for paying salary for the period work before termination. And, my lord, my appointment should not be fresh, it should be reinstated. Continuation of service will follow. So that in 99, my lord, the earlier pension policy was enforced. And from 2005 March only, the new policy has come. So I cannot be deprived since I have joined my service in, my lord, December 2006. December 1999. December 99, I have joined. Since 99, I'm continuously serving except the terminated period. So, although my service was terminated along with many other teachers, I have been reinstated by this honorable court, but instead of reinstatement, that is my prayer for modification of this order.
Okay, just 5 seconds.
Yes, ma'am. Having regard to the above, the repetition stand disposed of by holding that the herein are entitled the same benefits flowing out of the order dated so and so, passed in April so and so, 182 of 2013. It is, however, clarified that while making necessary exercise for effecting regulation, not fresh appointment, while effecting regulation of their service, the Education Department, Borderland so and so verified the case of the petitions and reach a conclusion as to whether they were regularly receiving salary up to 17 October 2006. In the event they had received their salary up to said period and had been serving in respective schools under the jurisdiction of Borderland Territorial Council, their services be accordingly regularized. It is accordingly regularized with the above findings direction, this petitions then disposed of. So, my lord, it's a clearly contempt of the court, my lord, because, my lord, court has ordered for regulation, but they are giving me fresh appointment. The first difference. And I have not only 2006, 17 October 2006, I have received salary up to 2008. So it's a clearly contempt. Court has directed for regulation and they are issuing me fresh appointment. But my other colleagues, they have been reinstated. That means continuation of service. And my prayer is, my lord, humble prayer is that, my lord, coming to the prayer portion, he has filed some of the affidavit. My prayer is at page page 12. Then from the middle, I'm reading the issue fresh order, allowing the petitioner for continuation of service along with all consequential service benefits. To modify the order, I'm not challenging for setting aside, to modify the order dated 1/4/22 issued by the Director of Borderlands and Council, giving the benefit of pension under the old pension policy since his date of initial appointment, dated 4th of December 99. Pay the area salary since 1/7/2008 to from 1/7/2008 to 8/10/2012 till the date of termination. So he was receiving salary up to my lord 38th of June 2008, not only 6, and for another period that is to the pensioner conference. So my prayer is, my lord, for the period I have worked, salary, and my lord, continuation of service along with the pension benefit.
He also claiming for all pension scheme.
Whole pension scheme I was appointed in 99, my lord. 4th of December 99.
When did the
New
pension-
policy come, my lord, on 1st of March 2005.
February?
1/2/2005.
1/2.
1/2.
1 February, 1st of February 2005. March আসলে February, no? And it's a solely covered case, since division bench order is there, single bench order is there. So there is no scope of deviation. That is my
This is
hypothesis.
also connected with that batch of writ petitions, or it may be a little different.
This is, it is connected to those series of cases, madam. That today is listed in, deliver the order for IM. This same thing, madam. What he is, that this petitioner's claims is that there are some other persons who also terminated in the earlier order in 2009. They have also come to the court, and these 2 orders have been annexed, my lord. Lord, they will, this my one friend has shown this 2 other, one of page number 47, Binoy Sohariari, Binoy Sohoria, and Pradip Sunma. These 2 orders have been shown by, they say that they are similarly situated. These 2 persons are similarly situated with the petitioner. So these 2 persons are regularized on a defined order, that is order WPC number 59 of 2013. And say this petitioner is also similar, so they have to be reinstated. So in fact, my lord, I have filed my affidavit showing that these 2 persons are different. They were terminated altogether, but there are 2 sets of persons. One is persons who have not been posted in a sanctioned post. And these 2 persons, along with few others, were posted in a sanctioned post. They were terminated together. Ultimately, both came before the court. And those persons, in a batch of cases, my lord, they were ultimately in the termination order was challenged. Termination order was upheld. Then the writ appeal came. Termination order was passed. Termination single judge on 21/3/2013 upheld the termination. Thereafter the writ appeal came. Writ appeal, there was the direction that the policy decision was taken by BTC that this person will be accommodated, and as the new sanction post will come. Then the sanction post came. In that sanction post, this person was accommodated. Petitioner was accommodated. Now he wants that there are another sets of persons who came before the court, and they have been regularized in the earlier post because they are sanctioned. In the affidavit, I have my affidavit, lordship, take up my additional affidavit, my lord. That starts from it is filed on 23/2024. 23/2024.
Additional affidavit.
My lord, my additional affidavit, my lord. It is filed by one Jagdish Prasad Brahmo. He is the director of education. Let's will turn to annexure 2, page number 70. So these 2 persons, when who have said that had been accommodated in the earlier post itself. These 2 persons, along with the other person, they have been dealt with by the inquiry committee, and order has been passed on 26 February 2019. My lord. 11 person is, my lord, what you will find in page number 76, my lord. It was this person who is petitioner before you, Lordship, at a different, and a non-sanctioned post appointed. These persons were appointed in a sanctioned post. Page number 76, my lord, second paragraph beginning with while considering the present petitioner's case, where their case are covered under the policy decision of BTC referred in WPA number 128 of 2013 batches, it may be stated that the case of the present petitioner, only teachers and the teachers referred in WPA number so and so batches stands on different footing and completely distinct from one another. In case of WPA so and so, the appointments of the teachers were not preceded by a normal selection process, such as no advertisement, publication, no selection, conduct, and no prior approval from the RSPL BSc authority and was obtained, etc., which was undoubtedly not a basic feature of the case of the present petitioner. The present petitioner instead went through a selection process as per the government rules. Therefore, as per the preliminary observation of the petitioner's case, it does not fit under the policy of the BTC referred in this batches line. Those two, Binoy Sahuria and other 2 persons, were appointed in a, they faced the interview board, they faced the advertisement, and they were posted in a sanction post. So they are treated separately in a distinct order, my lord. That is order dated 26 February 2020. That distinction has been made, and they were appointed. So it cannot be said that the petitioner also comes within the ambit of this writ petition number 59 of 2013. A different order has been passed. Therefore, they have been accommodated. And now, because of the writ appeal, my lord, thereby the policy decision was taken. Ultimately, the sanction post came, my lord. Thereafter, the petitioner was accommodated, my lord. Lordship will turn the writ petition that the order dated, that is page number 49. It is order dated 1st April 2022.
Page number
49 of the writ petition. The petitioner has been appointed, my lord, when the fair sanction post came. Fair sanction post, this person were appointed, my lord. In view of the fact that this makes a face appointment on 1st April 2022, the old pension scheme, he will not be covered with the old pension scheme. That old pension scheme and new pension is coming into effect from 1 to 2005.
Let us see the petitioner's appointment. Initially, he was appointed to the stipendary teachers.
Yes, initially appointed stipendary teachers. They were terminated, and the same batch came before the court.
1 minute.
He didn't approach the court. After the order was passed in the writ appeal, he came before the court. I am covered with the writ appeal case. I find that termination order was challenged and the termination order was upheld on 21/3/2013. Then the writ appeal came. Writ appeal order was passed on 6/2/2018. Thereafter, the petitioner came before the court in 2018, and the order was passed on 8/11/2019, saying that I am covered with the writ appeal order.
So what you're trying to say is that the petitioner's case falls under those
this group, and they were subsequently appointed after the sanction was granted by the SI.
See, in that writ petition, in those batch of writ petitions, if I'm not wrong, after the writ appeal order was passed, after the writ appeal was disposed of, Finance Department filed a review petition saying that the policy decision taken by the BTC did not have the approval of Finance Department. Correct.
During the pendency, we got 1009 posts.
Yes, 1009 posts was sanctioned. And
this appointment started.
Appointment started. Now, if I correctly remember, in those appointment orders, these were orders of October 2015, where they were given prospective regularization.
Yes, prospective. This person is also in the prospective.
But then how come that his order is of 2022?
2022, the subsequently.
At that period of time, the others were given with effect from 2015.
Some posts were left, my lord. Then their accommodation. We are doing it because the process is on that to accommodate all this person. And ultimately, as on date, my lord, what you will recall that 314 posts are still persons still to be accommodated. Thereafter, my lord, in the meantime, we got 1216 posts. Now the process is on to accommodate. This person is fortunate enough to get the appointment. And the process is on, others will get it simultaneously. In the most probably in the first, second week, or this entire process will be over. These similar orders of appointment will be issued. Because first of all, they have to get a post, sanction post. Then only appointment can be done. These persons are appointed, this particular person is appointed in a non-sanctioned post.
Which is the last affidavit that you filed?
Last affidavit is defined, my lord. Last affidavit means, my lord, last affidavit is filed on 18/7/2014, where the court wanted to, what is the policy decision, my lord? Is it the policy decision of the PTC or the cabinet? It is the, I have annexed the policy decision, my lord. It starts from page number 91, the type copy, my lord, relevant portion. Entire policy decision is from, the original copy is in from page number 94. This is the policy decision of the Executive Council of the BTC. Because there was a confusion whether it's the BTC policy decision or a cabinet decision of the government of Assam. It's the BTC policy decision. To accommodate all this, we recall all the termination order and a date was fixed for regularization of these persons. Those the person who have written its salary a particular date, they will be accommodated. Termination order will be recalled.
See, come to page 32. Or prior to that,
32.
37, 31B.
Yes. 31B.
Annex 7.
31B is not there, my lord. Annex 7 is there. 31, original copy is it. Original copy is there in my petition. That is Annex 7, page 31.
Page 31.
31.
Yes, we did.
Yes, my lord. Wherein the instruction was hereby following the time again, and the same same, as the other allocation or admission under the rule effect on the date of home against the employer means they yes, union basic examination. Then the value also is finding out the value sanction post. In fact, these such orders were issued, these were not in valid preference, therefore they were terminated. Lordship will turn to after an inquiry, my lord. Lordship will turn to page number 36. How they were page number 36, my lord. That order, my lord, and an entire list is given in pursuance of government order issued number so and so, dated 18/10/2012. The service of 285 out of 302, my lord, teachers appointed in the Dorong district as per the list appears in the enquiry report of the Deputy Commissioner Dorong and the enquiry report of the Director of Elementary Education Assam, hereby terminated. Then the enquiry was conducted. They are found that they are not appointed in the sanction post. This person
Is it mentioned in the inquiry report?
Not so therefore the enquiry report. After the enquiry report, this list was prepared. We were not appointed in the sanction post. That's why, my lord, they were after the termination, my lord. Patches of petition were filed. And this termination was upheld.
Was the petitioner part of the
Initially he is a fancier. In the writ petition, he has not been a party. In the writ appeal also, we are sitting. When the writ appeal order was passed to accommodate all the person in a policy decision, Thereafter, he came before the court. I won the same order as the writ appeal. He is a fence sitter. He was watching what is going on. He won the writ appeal order. And after the writ appeal order was similarly to be done, he got the appointment. Now he wants.
Was the inquiry report, produced before that, when they filed the writ petitions, before the single bench?
Well, single judge has taken everything into account.
Let us see what the judgment says. You have only one copy.
Hello?
You have only one copy.
Well, this is a certified copy. I have the copy. Mala.
You can make photocopies and bring it.
I have in the I have the copy, Mala, because in the earlier case, Mala, batch of case, I have annexed this particular copy.
Yes, sir. Hey, appeal. I don't
Appeal
think.
করছে
Huh?
appeal করছে
কি আবেদন করেন?
terminationটা appeal করছে
ওটা আবার single জায়গা।
single তো
Division bench से फाइल करा विषय करा single জায়গা তো বিকে শর্মা হ্যাঁ বিকে শর্মা থেকে আমি বিকে শর্মা থেকে বলছি না ওই সিকেস রায় বলছি আমি পুরো টোটাল বলছি পুরো আবেদন আচ্ছা তো ঠিক কিন্তু শর্মা রেসিকেশনের দুজনে করেছে কোন কোন শোনা আছে কোন শোনা যাবে হ্যাঁ এখন আমরা এরকম ছিল আমি বলছি বিটাটা করেছি বিকে শর্মা রাখা রেসিকেশ appeal करना है
Yes.
This order also, he didn't challenge in the initial stage. Later on, when the writ appeal was, the decision was taken, he came before the court. Saying I want the similar order that I am stated in the.
On the basis of the writ appeal.
Writ appeal. In the writ appeal, when the process started, because he is the post-war delay, he was accommodated. Now he wants the OPS, old pension scheme, OPS.
That is a different thing. Old pension scheme is now a different thing. We will come later to that. But the fresh appointment.
Fresh appointment. Because sanction is, they were supposed for sanction, as their sanction came. So he was one of the person who need to be accommodated.
Are you trying to say that there was no advertisement, nothing when the petitioner was appointed?
When the petitioner was appointed, there was nothing.
How about the other two?
Other two, the distinction was made, my lord, in page number 76. I have just read, my lord. For them, there is a batch.
Is it a reference? Is it a reference to the said two persons?
Yes,
Page
yes.
76.
Absolutely, my lord. That I have stated in that particular, my lord, order while dealing with Lord Civil. I have pointed out in page number 76. I think. Yes, my lord, 76. The order while the committee was there, it is passed by the additional principal secretary BTC. They have taken care of all deals. That distinction was made because these two persons, along with few others, my lord, they were all against sanction post. Sanction post, they were advertised and they have participated in the selection process. So their writ petition is also different. Writ petition is 59 of, yes, ma'am, 59 of 2013.
Just I'm interrupting for one second, madam. Actually, poster advertised, but excess appointment were made. 3-4 times, many more times appointment were made.
Where's the advertisement?
That my lord, I have to ask for advertisement. It's a 98 advertisement was made.
Was there an advertisement in the first place?
First place. But
Have
my
you
lord,
mentioned- have you
since
stated
my
in
lord,
your writ
that
petition?
time my lord, in many districts, excess appointment were made. And my lord, all were appointed as stipend officers.
No. Have you made
Subsequent.
that statement in the writ petition that on the
No,
basis
my
of?
lord, but that occasion has not come. I have come with some similar, some separate issue.
No.
My issue is,
In this writ petition,
yes, my lord,
have you stated that there was an advertisement?
I've not stated that.
Then
Because copy is not there now. I cannot furnish the copy now. It's my lord 25 years back. So I cannot furnish the copy now. So why should I make the statement? Because if I have to make statement, I have to place the record. So 25 years back, what was the advertisement? But my lord, generally, since we are appearing in the cases, we know, my lord, what was advertised, what was not advertised, and in many districts, not only this district. Many
because the clear stand of the respondent is that there was no
No,
advertisement.
he has also not placed any record. Where is the selection list and advertisement?
That in itself,
Selection list and advertisement he has to place because records is in their custody. It is not my custody. Although we appeared in interview, we were appointed as stipend officers, everybody. They were also appointed as stipend officers. Why they have been appointed as
Down to
stipend
page
officers?
76.
So without record,
76,
without record,
Lord,
should not
before
have
that,
submitted all these points. They have to place
why
the
this order has been
selection
passed?
list.
Because the order passed in writ petition number 59 of 2013. That is order dated 28/11.
He's digging the history now.
Yes, this is the order. There was a separate batch of persons who had come before the court, so there's a
No. You are seeking parity with these two persons, isn't it? You are
Not only
seeking
two persons, others, all
others
persons.
also, but
Yes,
then
ma'am.
you are giving
Yes,
an
yes.
example of these two persons.
Example, two persons.
So obviously,
And
he has to
yes,
show.
and 2005, with the same order, we have been regularized, my lord. 2005, from the same order, we have been regularized. If they would have been selected, that order would not have been passed against them, my lord, in favor of the petitioner and the other persons. 31B on page 32. When Mr. Bora was there, he appointed many persons, my lord. That's why I'm going. Bora said, Then they could take it. And he must be enjoying his grandchildren. He is even around. Even around, not a black person. Huh? English can have it. D on a DI. My relation is a full body.
There was a select list of 24, 29
This,
for
this
99.
persons, these persons were there, man. This person against appeared in the interview for the, I think there are 28 persons. On the first paragraph itself, there are 28 persons. There's a separate.
Would that, why make,
44 selected
give me the copy
Yes.
also? I should also be,
No, this is on, had taken out from the online, my lord, from our website, my lord.
you should take copy.
Petition number 59.
You have to give that copy to the.
Give her a copy,
council.
give her a copy of.
Yes, without seeing them, without, how can I
Because
reply?
I have annexed that order, particular order, my lord. The very first line is a petition number 59 of 2013. This is the order.
No. We are along with
Page
82.
number 70 itself.
Read the bill
First,
82.
first paragraph line, my lord.
Surely this is not the issue, my lord. He is deviating from the.
No, he's not debating. This is important.
Yes.
Because you are claiming parity with these two persons and others.
Yes, but
Others
I have
too.
placed some of the orders who
You have placed
which were
only
along with
two
us.
orders.
Yes.
Two orders. These two persons. These
These
two
two
persons.
persons and basic trade
They filed
also
a writ
passed together.
petition. They
Basic
filed a
trade-
writ petition before the court,
Yes,
which was registered as 59 of 2013.
yes.
All right. They got a favorable order and then the authorities, they examined the matter. They found that yes, when they were appointed, they went through the selection process.
Since he has not written anything in this affidavit, my lord, without any record, how can I, my lord, read it? Where is their name? Where is the name?
Order is.
Record is annexed to
Then
the affidavit.
give her a
I'm
copy of.
totally in dark. I'm totally in dark. What he is talking
the
about.
copy, my lord.
Copy where, in which line or which statement you have said that this persons were selected by this select list, interview was made by, and but this person to this advertisement, no whisper. Additional which is
Here reply also for the addition.
No, my lord. Reply, my lord. There is no whisper against my lord when their poster advertised, when they were selected, these two persons.
No, it is done
Nothing.
in the writ petition.
Without my lord, he has
Ah,
three
that-
affidavits
that
has
part-
filed.
that part I
I'm totally in dark, my lord.
Yes.
He has filed three affidavits, no whisper.
Paragraph
in
number
any of
5, I
them.
have said it.
Give her a copy of
What
this
I will give her?
judgment.
Yes, my lord. I will give you a copy. my lord. I have only one copy, my lord. I will
Which
give it,
page,
my lord.
which page?
Paragraph, page 60, my lord.
60, okay. Paragraph 5. Appointing the writ petition in
There is no
pursuit to
page,
the
paragraph number
subsequent
5.
essay approval, government
Very
resolution.
first line I have stated, my lord. This
That
person,
under
this
the
cannot be
remand
equated with
abbreviation
this
number
present
instruction
petition.
cannot be equated in the other typical Govinda Varman. Because, my lord, whatsoever the honorable court has passed the order in my case also.
Yes.
So he cannot sit as the appellate authority over the order of the honorable court. When the court says it is equal, how can he say that it is not equal?
It is on the basis of your policy decision that now you are trying to accommodate this person.
Policy decision, we got the advantage of the policy decision.
But in those batch of writ petitions, in fact, I clearly remember there was an order of October 2015 where you appointed these persons.
Yes.
Giving them
Yes,
prospective.
there are some person who as the post came, the post was there, then they were appointed. Subsequently, some person
That part you have to make it very clear in this
some
writ
person-
petition.
in the
So
meantime,
that the petitioner can rebut that. See, there were huge number of teachers who were terminated. They came to court, their writ petition was dismissed. They went on appeal. Before disposal of, you came up with a policy. On the basis of that policy, writ appeal was disposed. Correct?
it was closed, man, not in fact.
No, it was closed. Then you started making appointments.
Then the post came in. We started making appointments. Appointment were there in
So
the
there was the order of something of October 2015, correct? If I'm not wrong.
that order, my lord.
There were orders of October
This is of
2015.
my lord, February
In the writ appeal.
2015.
No, in
Writ
the
appeal?
only,
Writ petitions.
yes, in those days of writ petition.
Not so. No, in the meantime, my lord, we got the sanction order, sanction everything. We started doing everything, my lord.
Sanction was there, sanction
Later
1009 post.
Initial.
Initial sanction was given.
Then the post, then we started to appoint everybody, my lord. Then when some person has retired in that particular post, then the post came up, we accommodated it, it goes on, my lord. Then this person came up in the 22, this person also, petition also accommodated. Because the post is given to one person, then he will, if he retires, the post becomes vacant. If someone expires, that becomes vacant. No. He accommodated it.
You give her a copy of
Lordship. When I will hand over this part, I'll take a printout of this.
Yes.
Only one thing, my lord, I want to place regarding the last affidavit he has filed, page 92. This is the policy decision. I'm reading two paragraphs that page 92, second paragraph, that it was also clarified that from the policy decision, my lord, it was also clarified that the termination order of the 221 numbers of doubtful irregular appointed teachers were upheld by the Honorable Guwahati High Court. At present, the matter of termination order of these 221 numbers of teachers is before the division bench of the Honorable Guwahati High Court on appeal stage. The Executive Council meeting decided to withdraw the termination orders issued by the Education Department of BTC and allow the doubtful irregularly appointed 221. They says when everybody 221 laid down by the 221 numbers of teachers on fulfillment of terms and conditions laid down by the Director of Elementary Education, Assam, had order stated above with prospective effect. The doubtful irregularly appointed teachers shall continue to serve in their respective place of posting and draw salary thereon no work, no pay basis. So, my lord, whether I was appointed irregularly or illegally or regularly, but my lord, the decision has, my lord, the court also allowed, and my lord, here, my lord, the cabinet decision.
221,
Yes.
221 teachers we are
Yes.
talking about.
See for Barolan,
In this policy.
why he single
Then-
me out?
Then
Why I'm being single out?
he is not single line. Along with he is all.
Because
this petition is the only person.
when, my lord, the court has equated, court has equated, cabinet decision or the policy decision has equated.
He is the only person he wants to parity with other two persons. my lord.
Yes, my lord, because my service, if I am a irregular appointed person, why my service was open? Service book was open. I am paying the all amount, my lord, GPF, gratuity or whatever is all this.
When the policy decision was that he should have objected it, that I don't want the policy decision, that single judge order should be quashed.
Okay, you produce a copy to her after that, we'll
Lordship.
take up the matter.
So, my lord, my service book was open, my GPF account is there.
Also.
I'm regularized to other two persons in 2005, giving electricity reform from 2000.
It is,
So, why does same order passed?
is the matter.
When it is fixed, again,
How much time do you want to go through the judgment?
which judgment, my lord?
The WBC 59.
I've gone through and filed an additional affidavit also, my lord, regarding that.
WBC 59, the judicial
59,
conference.
yes, my lord, yes, that is there in the
So I'll
record.
give you a week's time.
Not necessarily, my lord, just now I can also place, my lord, additional affidavit, because 59 of judgment to law.
31st of July.
Already I have replied for it, my lord.
Now he said replied for it, my lord.
He has not given, I have take out, my lord, because in the second additional affidavit, he has taken that ground, my lord, and he has.
Okay, I've passed.
Now
all
he's
the-
not mentioning
Stop.
anything, passing the papers without mentioning, without giving a copy, that's why it is good, my lord. In the second affidavit, page 70,
I've already passed orders.
yes, so my 31st,
Five,
it will come as part of motion.
No.
Motion. Okay, madam.
5 admission.
কি কপি আছে তোমার কিবা নিদিয়া কপি আছে যে মোক দিয়া কোর্টত দিলে পিছত সুপাৰ হয় গতিকে মানে ফেয়াৰ হবে যে মানে আধাৰ কাউন্সিলক দিয়ে সুপ্ৰিম কোৰ্টতে এক মিনিটৰ এলাও নকৰে কেনেকৈ আধাৰ চাইডে আগতে দিব নেকি তাৰপিছত কোৰ্টত দিব কিন্তু তুমি এজেন্সি জ্ঞান না
Lordships, The petitioner is a assistant teacher, my lord. Was a assistant teacher. He has already been retired from service. On 31st of January 2017, he has already been retired. Now only the grievances has been left out of the petitioner, my lord. The arrear salary, my lord. In this regard, my lord, one after another, the honorable court passed the order. My lord. And even in that, in earlier occasion,
Yes.
may I continue? Sir? Then, of course, if I go through the honorable court's order, lordship will understand very easily, my lord, and it's a very simple matter otherwise. My lord, page 18, my lord, of the relevant portion starts from 16, my lord, WPC number 1119/2010, my lord. The relevant portion 18, my lord. My lord, I'm just reading out the last portion. Considering the matter in its entirety and in the interest of justice, this writ petition is disposed of with a direction to the respondents, particularly respondent number 5, namely Bodoland Territorial Council, represented by the Secretary Education Department, Kokrajhar, to ensure that the petitioner's salary and allowances, both arrear as well as current, are within the period of 8 weeks from today, made available to him. If for any reason the headmaster of the said school delays the preparation of the bill of the petitioner, respondents, particularly respondent number 5, namely Bodoland Territorial Council, represented by the Secretary Education Department, Kokrajhar, shall remain at liberty to take appropriate disciplinary or penal action against the headmaster of the said school in accordance with law. My lord, this is the order, my lord. Here, my lord, the arrear salary from 17/11/2008 to the second parameter, 17/11/2008 to till 22/3/2010. It was remained pending, my lord, after being reinstated in service, my lord. He was under suspension, then he was reinstated. Then, my lord, this period was, the salary was not paid. And accordingly, this honorable court directed the authority concerned to pay this arrear salary, my lord. And my lord, here, basically this headmaster of the Siddhesar ME school, my lord, against him, my lord, this for headmastership, my lord, this case was filed, my lord, against the headmaster of this school, because I was the senior most person, but he came from another school. That is why, my lord, he took the revenge, and accordingly, one after another, he caused a harassment to the petitioner, my lord. Anyway, my lord, this order was passed. Subsequently, lordship will find at Annexure B, page 21, lordship, this contempt case, my lord, 129/12, my lord. Then the relevant order at page 22, lordship. Nabashankar Chaudhary, District Elementary Education Officer, Baska, is personally present pursuant to the order dated 12/6/12 and explain the reason relating to non-appearance despite service of notice. The explanation given is accepted. The appeal is so and so, so and so. It is submitted by the respondent number 2 as well as Mr. D. Das, learned counsel, appearing for both the respondent number 1 and 2. That the order passed by the Honorable Court 12/8/11 in WPC number so and so has been complied with, and the arrear and current salary payable to the petitioner has been paid to the petitioner yesterday, that is on 16/8/2012. In support of such contention, Mr. Das, learned counsel, has produced the counterfoil.
That I read.
That. Now, lordship will find.
So that arrear salary for 17/11/2008
to 10.
22/3/2010 was cleared.
Cleared. Now, in the meantime, my lord, again, I have been made suspension, my lord, page 23, lordship. In pursuance of the Secretary BTC,
Bhai number so and so, and pending drawal of departmental proceedings, Sri Devi Prasad Ghimire, Assistant Teacher, Siddheswar ME School, under BO Govardhana of Buxar District is hereby placed under suspension with immediate effect. He is allowed to draw 50% subsistence allowance, so and so, so and so. And my lord, interesting, lordship will find with the condition that during the period of suspension, he will put signature in the teacher's attendance register from the very beginning and ending of the school hours. This is harsh, my lord, cannot be, my lord. Because once they are suspended, and again they are asking for putting signature in the morning and in the evening, my lord. Now, lordship will find that part, my lord, it has been now page next page, my lord. He has been that order has been partially modified, my lord, by the Secretariat letter number so and so 35/2013, and in the interest of public service, Sri Devi Prasad Ghimire, Assistant Teacher of Siddheswar ME School, is hereby reinstated and transferred to Madhya Hauli ME School. Because in Siddheswar ME School, there was dispute, that is why he has been reinstated, and thereafter he has been transferred to Madhya Hauli ME School in the vacant post arising due to expiry of Narayan Chandra Das, Assistant Teacher so and so, and the Govardhana Education Block. Well, so far this suspension order is there, that has been revoked and reinstated the petitioner, my lord, and he has been transferred. So now whatever the suspension period arrear salary is there, that is I am entitled, but they are not paying as on today, my lord.
What is the period?
That period I will come to the, my lord. That period is there, my lord, since 2010, my lord, up to 2000. That is arrear salary was paid from 2008 to 2310. Thereafter, my lord, whatever the amount was there up to the 9913, up to 9913, because this order was passed 22nd of August 2013. Then, my lord, ultimately he joined on 10/9/13, my lord, in the new. He joined, my lord, page 25, as per this order, my lord. The petitioner joined on 10/9/13, my lord. So up to 9/9/13, he was there, my lord, in Siddheswar ME School. So that part, my lord, he is entitled for arrear salary, my lord. Now, against that, my lord, this petitioner came before lordships at page 26, my lord. That is 1802/2014, my lord. Then in the case, my lord, another case was also filed by Siddheswar ME School, the headmaster, my lord, against whom there was a rift between the parties, my lord. Now, this order was passed, page 28, my lord. Here, my lord, I am reading in the second paragraph, in the first writ petition, the WPC number 1802/2014, the prayer of the petitioner is to direct the respondent to release his salary, both arrear and current, stated to be payable from March 2012. It has been corrected, my lord, in the page 31. It is 10. Page 13, it has been, the honorable, I came with the IA, my lord. So it has been corrected as 10. March 2010, the petitioner is an ME School teacher and he was transferred from Siddheswar ME School to Madhya Hauli ME School by the order dated 28/8/13, and he joined the new school on 10/9/13. Thus, according to the petitioner, he is entitled to receive salary from March 2012 to 9/9/13 in his earlier school, namely Siddheswar ME School, and from 10/9/13 in the new school, namely Madhya Hauli ME School. In the second petition, WPC 6522/13, filed by the Siddheswar ME School, the prayer is to direct the respondent not to pay the salary to the petitioner so and so with effect from 22/8/10 till he was released from the said school pursuant to the above mentioned transfer order. As noted above, the petitioner involved in WPC number 180214 claim for salary in the new school is from 10/9/13. It will be pertinent to mention here that pursuant to the order dated 12/8/11 passed in WPC number 1119/2010, which was filed by the petitioner involved in the first writ petition WPC 180214. He had been paid salary up to February 12. In the said writ petition, direction was issued to pay salary to the petitioner, both arrear and current salary. Being agreed by the said order, the petitioner involved in the second writ petition, namely Siddheswar ME School, filed a review petition being number so and so. The miscellaneous case was disposed of upon withdrawal with liberty to the petitioner to approach the scope by filing a writ petition with the liberty. The Siddheswar ME School filed a writ petition, second writ petition, WPC number so and so, and while entertaining the said writ petition, this court by an interim order 13/11/19 restrained the respondent number 6 from disbursing salary to the petitioner involved in WPC number so and so, namely Devi Prasad Ghimire. The whole basis of the prayer of the petitioner in WPC 6522/2013 Siddheswar ME School is that the petitioner did not attend his duty from 22/8/10 till 9/9/13, that is till he was transferred to the new school. On the other hand, it is the case of the petitioner in other writ petition being WPC 1802/14 that he all along attended his duty but was not allowed to sign in the attendance register, which was also the plea in the earlier writ petition filed by him and referred to above. Above being all disputed questions of fact were requiring ascertainment of the vacancy or otherwise of the pleas taken by the petitioner involved in this proceeding, it will be appropriate for the BTC authority to ascertain the real state of affairs in the matter and then to take appropriate decision in the matter, strictly in accordance with law. Accordingly, both the writ petitioner are disposed of directing the BTC authority to resolve the issue as regards the payment of salary to the petitioner WPC number 1802/2014, namely Devi Prasad Ghimire, for the aforementioned period, taking note of all the attending facts and circumstances and in accordance with law. In the process, the said authority may hear the relevant parties, including the parties involved in this proceeding. Let the required exercise be carried out by BTC expeditious as regard the current salary stated to be payable to the petitioner involved in WPC number 1802/2014 in new school. The BTC authority shall take appropriate decision immediately, preferably within 10/5/14. Thereafter, Lordship will find the court's order, honorable court's order at page 31, my lord. There was a March 2012 that has been already corrected, my lord, here. The March 2012 shall be read as March 2010 in the said order, miscase 10 disposal. Now, my lord, on the basis of that, my lord, page 32, my lord, on behalf of the petitioners, this application, this notice was, application was submitted by the concerned council, my lord, to consider the claim of the petitioner. Now in 2017, my lord, page 34, my lord, the petitioner again approached this honorable court, my lord. That is, relevant portion starts from 35, my lord. Third learned constituency, it has been submitted that the petitioner has received the pensionary benefits, however, as regards the arrear salary from 23/3/10 to 9/9/13, the same has not been paid to the petitioner while serving as an assistant in Siddheswar ME School, Barpeta, along with the revised pay scale and senior grade pay since 2010. The authority will release the arrear salary along with revised pay scale and also the senior grade pay if the petitioner is found to be entitled after proper verification. This exercise shall be undertaken by the responding authority within a period of 3 months from the date of receipt of the certificate copy of the order. My lord, here, next, my lord, on the basis of the honorable court's order, again, this petitioner submitted an application to the authority concerned page 37, my lord. On 6/12/2019, my lord. To consider his prayer for arrear salary as well as for revised pay scale and senior grade pay scale. And subsequently, the another petition, my lord, that is at page 38. my lord. And well, in the meantime, Lordship will rise with it.
Lordship, I think Lordship fixed a date, Lordship last on 30th August.
Nah, I'm saying after 4 weeks.
Lordship.
So it will come up.
Lordship.
So in the meantime, even if you can make some adjustments.
That will come in. As peak of August, it will.
This will be in the agreement issue. This is the item. I don't know. Anyway, let's see what the other thing. I think not. I think.
Item 5.
Chetri, I don't know if I can continue. I'm having some health issues. I don't know. Anyway, let's try.
No, Lordship, there, I have to take time to reply also. It will be quite long. Because more, text will be quite long. I need some time to reply also. Then Lordship can proceed in any other day.
Okay.
Lordship will fix the date.
Lordship will be Chetri, then a council for petition also had as oral understanding also BTC. BTC isn't it?
Lordship.
Is the matter? When do you want?
Next Thursday or like
August 6th. August 6th or 8th.
well, it will be too late.
6.
Item number 9 to 11, my lord. Can it be on 1st of August, my lord? I have some little urgency in the matter, my lord. And deeply obliged. 1st of August, my lord.
I was thinking of taking, unfortunately,
My lord.
something started happening.
In fact, my lord, Lakshmi cannot take up this matter because one of the cases, PDP don't reply was filed yesterday. It has not come on record.
On 1st of August, my lord.
My friend had filed a PDP.
1st of August.
1st of August.
Who filed the reply, David?
I have filed it.
In which case?
In item number 10. 11, my lord.
Just check up with the reply.
Yesterday evening, I have received.
It was filed yesterday.
Afternoon.
You filed it yesterday?
Yes, sir.
Item 9, 10 and
Yeah, got to, yeah, got
It's
petition.
the T. Chakravarti and the council for the petition. Appealing for the petitioners. In WBC 7626 of 2020. Submits that he has filed an affidavit in reply on 24/7/2020. We need to verify and place the summary. And list these matters again on give a date.
1st of August, my lord.
First August.
And deeply obliged.
NC Das was there on the
Yes,
VC.
Yes, my lord.
In item 10,
10.
this one number 4.
Okay, then you can tell him.
I will inform him, your lordship. Much obliged, your lord.
Laptop or meta that I think 12 plus. Well, look, my friend has given that communication lordship letter. Perhaps the lordship, this letter will not solve this problem. Well, look, may I suggest one thing, lordship? Since the matter is relating to NOC and no audit report, lordship, may I pray, lordship, this matter may be kept in pending and director may be directed to cause an hearing with the participation of all concerned, and after that he will place the report, and thereafter your lordship take decision whatever, what will be the appropriate for this instant case, lordship. Otherwise, in this way, lordship, this type of lordship instruction will not solve this problem, lordship. Now the respondent number 7, who is the principal of the college, lordship, he is, lordship, very peculiar person, lordship. He is creating all this problem, lordship.
Yes, Mishari.
That may, lordship, perhaps solve this problem.
Lordship, principal has given his report. It is in the third page. In the third page. Lordship, here.
That notice, lordship, that APS, lordship, I have received from my client just before lunch, lordship, is indicate that he has been asked to submit the paper,
Lordship,
clearance.
we are saying that we have communicated with the petitioner, but he is not cooperating. And here petitioner is saying that we are not cooperating, we are not giving him a chance. So, lordship.
No, I am not saying that we are not cooperating. I am ready to cooperate with the authority, lordship. Whenever authority will call, lordship, I will appear. Oh, no, you have to correct it.
Lordship will take it some other day if your lordship, since your lordship is not well, your lordship, some other day.
Okay, by that time we
Lordship,
try to
lordship,
fix
lordship,
it.
some other day. No, some other
But
day,
M
since
can't
your lordship is
look
not
for
well.
the petition. MSD Mushari, the standing counsel,
Secondary education.
secretary education shall take further instructions in the matter. 1 week time,
Lordship.
list down.
First of August, lordship.
Second up.
Lordship.
Obliged.
Obliged.
And yesterday also, we are filing that amended memo as per earlier order.
Have you filed it?
Yes, Lordship. Yesterday.
It's on record.
For the flag mark logos. Flag mark logos.
You are appearing on behalf of
On behalf of petitioner, Lordship.
the council, M. Goswami.
Yes, Lord.
Okay. It will be Ken Chowdhury, I think.
Ken Chaudhary and
Assistant Mr. M. Goswami. Short Mr. Ken Chowdhury. Assistant Mr. M. Goswami. Also heard Mr. Mr. D. Saikia, Advocate General, Assam, putting on behalf of the state as well as the PTC.
Lordship, for the state of Assam, I am assisting the learning advocate general. Lordship, if stated, my name may kindly be reflected.
Okay, also heard.
Lordship, P.
D.
Borua.
Saikia, Learned Advocate General, that is MS.
P. Borua.
P. Barua, Learned Council representing the state of Assam as well as the PTC. MSMDB, Learned CGC, for the response number 1. Mr. R. Huh? Appearing on MSLDB, Learned CGC, appearing on behalf of Mr. Architect, Learned PTC or HSC.
Designation is
DYS.
EY. Solicitor General of India. For Respondent 1. Ardhar, Standing Counsel WBP NPC for Respondent number 4. And Mr. T. Dury, Learned Counsel for the Respondent 11 to 20. Stop. It is submitted that the petitioners have filed the amended prospectus on yesterday was 24.
24.
Registry to verify the place the same money. Hearing concluded, just move it. Then you do audio on forward, please, take care, huh? So to have external,
Worship,
as well as Mr.
SR,
Saraba, huh?